It's June 27th, 2026. Welcome to yes2hellwith.com. There are books that explain the law. There are books that influence the law. And then there are books that change how judges think about themselves. One of those books is The Nature of the Judicial Process by Supreme Court Justice Benjamin Cardozo. For more than a century, it has shaped generations of judges, lawyers, and law students. It remains one of the most influential books ever written on the role of the judiciary. But influence alone does not make a philosophy correct. Before Cardozo, the American ideal of judging emphasized restraint. The judge was not viewed as the creator of law. He was not expected to shape society. He was not to determine public policy. His duty was to interpret and apply the Constitution and the laws within the limits imposed upon him. The Constitution separated powers for a reason. Legislatures were to make the law, executives were to enforce, judges were to interpret. Each branch was restrained by constitutional boundaries. Cardozo challenged that understanding. In The Nature of the Judicial Process, he argued that judges inevitably do more than interpret. They weigh precedent, they consider history, they balance competing interests, they evaluate public policy, they adapt legal principles to changing social conditions. In other words, judges participate in shaping the law. Many praised Cardozo for his honesty. But honesty is not the same thing as constitutional fidelity. The critical question is not whether judges exercise discretion. The critical question is whether they should. Once judges begin viewing themselves as participants in the development of public policy, rather than restrained interpreters of delegated constitutional authority, the role of the judiciary fundamentally changes. The focus shifts. It shifts from constitutional limitation to judicial judgment. It shifts from delegated authority to institutional wisdom. It shifts from asking, what does the Constitution permit, to asking, what result best serves society? That is a profound philosophical change. And history demonstrates that when constitutional limits yield to judicial discretion, government power rarely contracts. Rather, it expands. Just a few years after publishing his book, Cardozo authored the majority opinions in Stewart Machine Company versus Davis and Helvering versus Davis. Those decisions upheld key provisions of the Social Security Act through a broad interpretation of Congress's taxing and spending powers. Whether one agrees with those decisions or not, they became part of the constitutional foundation supporting the modern administrative state. That is why Cardozo deserves careful study, not because he explained how judges think, but because his philosophy helped legitimize a broader conception of what judges believe their role to be. Now compare that with the Liberty Dialogue system. The Liberty Dialogue system begins from the opposite premise. It does not trust government discretion. It trusts constitutional limitations. It does not ask whether judges can reach wise results. It asks whether the government has first established lawful authority to act. The Liberty Dialogues begins with a sequence that cannot be ignored. Authority, jurisdiction, status, standing, presumption, obligation, enforcement. Every step depends upon the one before it. If authority has not been established, jurisdiction cannot be presumed. If jurisdiction has not been proven, obligation cannot simply be imposed. If obligation has not been lawfully established, enforcement becomes constitutionally suspect. The Liberty Dialogue system rejects the idea that constitutional questions should yield to policy preferences, social needs, or administrative convenience. It insists that delegated authority must be demonstrated before government power may be exercised. That is the antithesis of Cardozo's philosophy. Cardozo begins by asking how judges should exercise discretion. The Liberty Dialogue system asks who authorized that discretion in the first place. Cardozo begins with confidence in judicial judgment. The Liberty Dialogue system begins with skepticism of government power. Cardozo places the judge at the center of the analysis. The Liberty Dialogue system places the Constitution at the center. The founders did not design a system that depended upon wise judges. They designed a system that depended upon limited government. Liberty has never been preserved because those in power exercised good judgment. Liberty has been preserved because those in power were confined by constitutional boundaries they could not lawfully exceed. That is the difference. One philosophy asks how power should be exercised. The other asks whether the power exists at all. And that may be the most important constitutional question any free people can ever ask. And as always, may truth reign supreme.